and it's unfair to hold the military accountable if the current law, if you're complying with the current law and it's later changed. So we've got a situation in which the people on the ground felt they were dealing with some high-value targets, and the Department of Defense approved certain techniques that they felt did not violate the terrorism statute that prohibits severe pain being inflicted. It didn't say you couldn't stress an individual or other things like that. And so if we went too far on some of those areas, I hope we didn't. But if we did, then I think in the process of the Supreme Court and all these hearings and all, for goodness sakes, we certainly are doing much better in that regard. But it is not the kind of rogue activity that has been suggested. There was no doubt about it. Our military felt that this country was threatened after 9/11. They were able to apprehend some of the key players in that, and they desperately wanted intelligence to make sure that if there was another cell group out there planning a similar attack, they could be stopped. And I believe they consulted the legal system all the way up to the Department of Justice, and hopefully in the future we can create a policy that we can all agree on. But I just don't think we ought to disrespect our men and women in uniform who've done their best to serve their country at a time when this nation saw itself under real threat. Thank you, Mr. Chairman.
Thank you. Senator McCaskill.
Mr. Chairman, with the utmost respect for my friend from Alabama, I think that we disrespect the men and women in uniform if we don't have this hearing. I think that this hearing is incredibly important for those men and women and for the rule of law that they stand for and for the kind of democracy that we want to be and that we want the rest of the world to be. Mr. Schifrin, I know that you are a lawyer, and I would like to ask you, did you review the legal memorandum that was written by Lieutenant Colonel Beaver that issued the opinion that these aggressive techniques of interrogation were in fact legal under federal law?
No.
So have you ever read it?
No.
Well, would you...
Not to my recollection.
If you were reading a legal document as a trained lawyer and you came across the phrase immunity in advance, would it cause you pause?
Yes, Senator. In my former life, I was a prosecutor.
Well, me too.
And that is something to be scrupulously avoided, at least my training was.
Well, immunity in advance, I want to make sure that we get on the record what immunity in advance actually contemplates. If I were a police officer or I were an officer of the court and I said to someone, now if you go drive the getaway car for the armed robbery and afterwards if you tell us all about it, we'll make sure that you're not prosecuted for the armed robbery. That would in fact be immunity in advance, wouldn't it?
That would be one example, yes.
And what you'd really be doing as an officer of the court or as an officer sworn to uphold the Uniform Military Code of Justice is you would be saying ahead of time, it's okay if you break the law.
You're saying that whether it's legally effective or not is another question.
But, well, that's another whole line of questioning. I'm talking about that phrase and whether or not any lawyer who would read that phrase would go, what planet are we on? There is no such thing as immunity in advance. That would be a crime.
I can say from my personal experience, I never used or made sure that it was never used giving someone immunity in advance.
And in fact, as I just said, if someone actually visits with someone about committing a crime and says, don't worry about it, you can commit a crime and I'm going to give you immunity, wouldn't they, under our principles of law in this country, be guilty of a crime?
They could be, Senator.
Well, that's what I am trying to figure out here. This legal memorandum that was the basis for our Secretary of Defense saying it's okay to hood someone when they're naked and sick dogs on them contained a legal theory called immunity in advance, and no one, I assume that you never had a discussion with your boss who got this memo about this.
That's correct.
And he is a trained lawyer.
That's correct.
Has he had experience as a prosecutor? Has he had any experience in a criminal courtroom?
I don't recall.
It's just mind-boggling to me that that phrase would be written and that no one would hear the raging sirens and flashing red lights that that phrase would in fact embrace under the rule of law in the United States of America. And it's hard for me to understand. Let me ask you, what are the names of the people that gave you the impression that we needed to have different or more aggressive interrogation techniques? Who told you that?
I don't think that's what I said. My recollection is that in discussion or being in meetings with a number of people in the General Counsel's office, I mentioned meetings when General Dunleavy would report, there was a discussion about the progress or sometimes the lack of progress in obtaining useful, actionable intelligence out of detainees. The meetings were usually chaired by Jim Haynes. There could have been any 3, 4, 5, 6 other lawyers there.
Could you give me the names of the other lawyers that were there where you would have gotten this impression that we needed to do something different than we were doing in terms of our interrogation techniques? Besides Jim Haynes, who was in the room?
Again, the way I characterized it was that there was some frustration with the quantity and quality of information being obtained. I didn't say that we needed to change techniques.
Okay.
Lawyers who were participating, there was Deputy General Counsel for Legal Counsel, Whit Cobb. I believe that the Deputy General Counsel for International Affairs, Charles Allen, was probably in some of these meetings. There was a Marine Major Lieutenant Colonel who worked in the Legal Counsel office, Bill Lietzau. Again, I can't attribute any particular statement to any of them, but those were there was a lawyer who's now my successor in intelligence, Eliana Davidson, who was responsible for the detainee operations matters. I think those were the lawyers who at least would have been present at the time of these discussions took place.
Were you ever present in a meeting with Mr. Haynes at or near or after the time he recommended to Secretary Rumsfeld that he approve most of these interrogation techniques? Some of them that he did not approve in category number 3, but he certainly approved hooding naked people and sicking dogs on them.
If you gave me the date, I, of course, met with Mr. Haynes every day.
Well, I can give you the date. The date would have been, he recommended the approval of these interrogation techniques that had been deemed legal in the same memorandum that talked about immunity in advance on November 27th, 2002. And the recommendations were approved on December 2nd, 2002.
I don't remember having or being part of a discussion on them. I have a vague recollection of hearing that the memorandum had been approved.
And so you are aware the memorandum existed?
Yes, but I could have been aware in the beginning of January or later. In other words, I don't have a recollection of a contemporaneous knowledge of it.
I think you're probably, a really good lawyer, and I think you probably care deeply about your country. And, I'm trying not to be, we're trying to figure out here, who decided that we were going to go down this road? And when did it get decided?
Well, it wasn't me, Senator.
I understand that, but you were much closer to it than any of us were. And if we're trying to figure out, did this come from Dick Cheney to Rumsfeld? I mean, Mr. Addington is still at the White House. Did this come from Gonzalez's shop? Did this, Michael Chertoff was down at the meeting in Gitmo talking about this. I mean, you know, there are still people involved in the periphery of this that are in positions of responsibility today in our government. So our frustration is we would like to hold someone responsible, and it's like trying to catch shadows here because no one is willing to say where this came from. This